In this lecture, we would like to discuss a recent judgment of the Supreme Court regarding the very role of Competition Act in solving the very insolvency and bankruptcy courts where the particular important leading case, that is Independent Sugar Corporation Limited versus Girish Sriram Juneja, which was decided in 2025, relating to that the bench held that obtaining competition commission clearance before presenting a resolution plan to creditors was mandatory and not directory. So the Insolvency and Bankruptcy Code of 2016 was brought in as a time-bound solution to the problem of interminable winding of proceedings. It provides for strict timeless lines to complete the resolution process, even as the company keeps its business running. However, adherence to timelines has proved challenging in practice. We are looking at an average of over 2 years to conclude the resolution process. For time to time, the courts have had to step in to provide answers to the problems posed by resolution processes that did not finish on time. A subset of these problems is when the procedure provided in a different legislation delays resolution. So, in the very particular, in this leading case, that is Independent Sugar Corporation Limited versus Girish Sriram Juneja, in particular, the problem arose where the apex court had to consider a situation where the timelines prescribed by the Competition Act of 2002, as per the provisions of Section 2, Section 2A, and Section 29 1 and Section 31, were interposed into the timeline laid down by the Insolvency Bankruptcy Code. So, in a 2-1 majority judgment on January 2025, a three judge bench of the court relied on a fluent reading of the Insolvency Bankruptcy Code to conclude that the provisions calling for approval of the Competition Commission of India before submitting a resolution plan to the Committee of Creditors was mandatory and not directory. Justice K.S. Roy authored the majority opinion for himself and Justice Sudhanshu Dhulia, while Justice S.V. Bhatti dissented. Review petitions against the decision have been filed before the Supreme Court and are expected to be heard soon. So the very path to the Supreme Court this case concerned the takeover of an indebted company called the Hindustan Glass and Industries Limited, which had 60% of the market share of India's glass packaging industry. The successful resolution applicant in the insolvency proceeding was the Greenpac Ltd or AGI, the company with the second largest market share in glass packaging and manufacturing. The combined entity of Hindustan Glass and Industries Limited and the Greenpac Limited or AGI would likely have had overwhelming dominance in the glass packaging industry, particularly within this subsegment of food and beverages and alcoholic beverages. One of the provisions of the expression of interest for taking over Hindustan Glass and Industries Limited as noted that any suitor would have to mandatorily obtain the approval of the Competition Commission of India before its resolution plan is approved by the Competition Commission. But the resolution professional had relaxed this condition so that Competition Commission of India's approval could be obtained after the Competition Commission's approval of the resolution plan, but prior to filing an application before the National Company Law Tribunal. So, the Greenpac Limited or AGI's first filing before the Competition Commission of India was declared invalid and they were asked to file a Form 2 along for notification for approval. So the Greenpac Limited or the AGI submitted its resolution plan to the Competition Commission before it had filed this Form 2. Promptly after the plan was accepted by the Competition Commission, it was challenged in the National Company Law Tribunal by a competing suitor for Hindustan Glass and Industries Limited, Independent Sugar Corporation Limited. So, Independent Sugar Corporation Limited's plan had received 10% less votes than Greenpac Limited or AGI's plan in the vote carried out by the Competition Commission. And the very meantime, the Greenpac Limited or AGI applied for Competition Commission of India's approval, which was granted subject to a voluntary modification. It proposed that it would invest one of Hindustan Glass and Industries Limited's plants. The National Company Law Tribunal approved this modification plan. So the Independent Sugar Corporation Limited challenged this in the National Company Law Appellate Tribunal. The National Company Law Appellate Tribunal upheld the decision of the National Company Law Tribunal, noting that while it was mandatory to obtain approval of the Competition Commission of India under the Insolvency Bankruptcy Code of 2016 for such a combination. The requirement of obtaining such approval prior to the approval by the Competition Commission was only directory. So, the Independent Sugar Corporation Limited appealed the National Company Law Appellate Tribunal's decision in the Supreme Court. Essentially, the apex court was called on to answer whether the resolution plan was vitiated by the fact that Greenpac Ltd or AG had not obtained approval of the Competition Commission of India before approval of its resolution planned by the Competition Commission. The very provisions relating to these developments and these provisions which play were the provisions under Section 31, subsection 4 and Section 12 of the Insolvency and Bankruptcy Code and Section 6, subsection 2, then subsection 2A, section 29, subsection 1 and section 31 of the Competition Act, along with the Competition Commissions of India's regulations on combination. So, section 31, subsection 4 provides that when a resolution plan is approved by the National Company Law Tribunal, the applicant must obtain the necessary statutory approvals within a year of such approval. The provision creates an exception to the rule as it applies to combinations under Section 5 of the Competition Act. It requires that the applicant obtain Competition Commission of India's approval prior to the approval of the resolution plan. So, in that context, we would like to discuss one important judgment of 2019 relating to the matter of combinations, and that is Mittal India Private Limited versus Abhijit Gudakurta, and it was decided in 2019. The National Company Law Appellate Tribunal held that the provisions to Section 31 subsection 4 was not a mandatory requirement but a directory provision. This view had been followed by the National Company Law Appellate Tribunal in cases like Makul Trading Limited versus Rajiv Chakravarti in 2020 and in Vishal Vijay Kalantri versus Selen Saha in 2020. Challenges before the Supreme Court in these two cases had not resulted in a reversal of the National Company Law Appellate Tribunal's decisions. Separately, the scheme for approval of combinations is detailed under Section 6 of the Competition Act, read with the Competition Commission of India's regulations on combinations. So, Section 6, Subsection 2A provides for a 150-day period. The procedure for investigation envisages under Section 29 envisages a prima facie finding on appreciable adverse effect on competition. So the National Company Law Appellate Tribunal has previously granted extensions overriding the timeline for completion of the insolvency process. Such extensions have been endorsed by the apex court or the Supreme Court. So, in the Committee of Creditors of Ishar Steel vs. Satish Kumar Gupta in 2020, the apex court held that the timeline of 330 days in the second provision to Section 12 of the Insolvency Bankruptcy Code was directory and subjected to the approval of either the National Company Law Tribunal or National Company Law Appellate Tribunal. So, in another important leading case, and that is Whispering Towers Flat Owners Welfare Association versus Abhay Narayanan in 2022, the National Company Law Appellate Tribunal relied on this view to condone a delay of over 730 days. So the very contention of the Supreme Court in the Independent Sugar Corporation Limited versus Girish, Sriram, Juneja in this important leading case in 2025, the apex court contended that the requirement under the provision to Section 31 Clause 4 is mandatory. It also argued that there is no inconsistency between the timelines under the Insolvency Bankruptcy Code of 2016 and the Competition Act of 2002, as upon finding a prima facie case for anti-competitive practice, the Insolvency and Bankruptcy Code's timeline can be extended in deserving cases. Further, the Independent Sugar Corporation Limited contended that conditional approval from the Competition Commission of India as for the approval of the plan is not only contrary to the scheme of the Insolvency Bankruptcy Code but also creates an unfeasible sequence. So, the Greenpac Ltd or AGI relied on the National Company Law Appellate Tribunal decisions and purposive interpretation to contend that this provision is directory in nature. The Greenpac Limited or AGI also contended that the reference to the Competition Commission in the provision to Section 31 Clause 4 was a legislative error, but at best and it should have been a reference to the adjudicatory authority, that is the National Company Law Tribunal. The Competition Commission on its part argued that the provision is directory given that the time-bound resolution process is geared towards maximizing asset value, and there was a need to harmonize the statutory timelines of the Insolvency Bankruptcy Code and the Competition Act. And finally, the Supreme Court in this particular leading case, while ruling in favor of Independent Sugar Corporation Limited and the provisions being mandatory as it was held by the bench that found there was no need for purposive interpretation. The language of the statute was unambiguous and not in disharmony with the scheme and intent of the Insolvency Bankruptcy Court. Since the Competition Commission of India has the option of approving, rejecting, or modifying proposed combinations, it was clear that the legislature intended a resolution plan to be placed in front of the Competition Commission for approval. One of the issues of timeline harmonization on which the court took the view that a conflict would arise only in cases involving an extremely high degree, mostly indicative of a complicated super monopolistic. So, based on the Competition Commission of India's annual general report for 2023, the court noted that the average time taken to dispose of combination applications was only 21 working days. Further, the court also pointed out that the application for competition commission's approval can be made at any stage after execution of any agreement or other document for acquisition, much before the plan is submitted to the resolutional professionals. So, further the court held that shortening of approval timelines under the 2023 amendments to the Competition Commissions Act of 2002 from 210 to 150 days for the approval of a combination proposal and from 30 to 15 days for a prima facie opinion. So, while distinguishing Arcelor Mittal's case and other national company law appellate tribunal decisions, the Supreme Court set the factual and legal context of those cases were materially different. For instance, the resolution process in ArcelorMittal had commenced prior to the introduction of the provision to Section 31, Clause 4. Further, the bench noted that the decision in ArcelorMittal lacked reasoning for considering the provision as directory. The judgments that followed the ratio of ArcelorMittal case also did not provide any reasoning for the same. So factually the court said none of these matters examined the necessity of Competition Commission of India's approval before an application to the Competition Commission. The bench also considered the ramification of a situation where the Competition Commission of India's approval is not obtained before an application to the Competition Commission, it felt that it would fall foul of various sections of the Insolvency Bankruptcy Code, which placed an obligation on the resolution professional to ensure that any plan placed before the Competition Commission does not contravene an existing law. It would also pose challenges to the Insolvency Bankruptcy Code stipulation that a plan approved by the Competition Commission cannot be modified in any manner by the Tribunal. Further, the Code also briefly touched upon the challenges posed by conditional approvals, which often opened the door for prolonged negotiations and further modifications. Conditional approvals were at variance with the objective of the Insolvency Bankruptcy Code to lay down a process facilitating finality and decisiveness to the very issue that was involved, as Supreme Court was categorical in holding that if prior approval of the Competition Commission of India is not obtained, it may lead to one situation where the Competition Commission may approve a resolution plan which violates Section 6 of the Competition Act, leading to Competition Commission of India rejecting such a combination and rendering the entire process futile. The judgment affirms the regulatory stance on gun jumping, the term used in antitrust law and explained by the Honorable Court as denoting the premature or unauthorized consummation of a transaction prior to obtaining mandatory approvals, and clarifies the very alignment of the Insolvency Bankruptcy Code with the statutory framework of the Competition Act. At the same time, the judgment does leave some open questions. What happens to cases that involves an extremely high degree of SEC? Also, in a situation where there is more than one suitor who triggers combination approval, is it feasible for the Competition Commission of India to consider all such proposals, though only one will be chosen? Should the resetting of the clock at various stages of combination approvals be factored in by the Insolvency Bankruptcy Code provision? These were vital concerns to have been discussed in a case that was expressly about the chicken and egg situation involving two statutory timelines. This was also the appropriate stage to have considered whether a fast tracked process for insolvency bound combinations is the need of the hour, as suggested in the March 2018 report of the Insolvency Law Committee. So some questions around the general procedural design of the combination investigation are also ripe for reopening. For instance, which parties should the show cause notice by the Competition Commission of India. So in the present case, the Competition Commission of India issued notice only to the Greenpac Ltd and not the Hindustan Glass and Industries Limited. The second question, how are the voluntary modifications proposed by the acquirer envisaged under combination regulations? The review petition are expected to relook and address some of these issues. The petitions are being closely watched, including by the Workers' Union of Hindustan Glass and Industries Limited, which had written to the Competition Commission, alleging that the erstwhile promoters had been colluding with the Greenpac Ltd or AGA to derail the resolution process. So, these are the views expressed by the apex court while deciding the very combination process applied by the Greenpac Ltd as regarding acquiring Hindustan Glass and Industries Limited, and in that connection we have discussed all the contentions raised by Supreme Court and examining the very provision under Section 31 Clause 4 of the Competition Act 2002, which itself expressed as a mandatory provisions, and where it was exactly laid down the powers of the Competition Commission of India and the 2023 amendment to the Competition Act, and on regarding the National Company Law Tribunal's decision on Mittal decision of 2019, and also the Competition Commission of India's approval and the Insolvency Bankruptcy Court's resolution professional in regards to the very combinations and for acquiring the very company relating to Hindustan Glass and Industries Limited, and in particularly the key issues involved that we have discussed the judgment in brief that tendered by the apex court that Competition Commission's clearance before presenting a resolution plan to creditors was mandatory, not directory as per the provisions of the Competition Commission Act 2002, and also in connection to the issues raised regarding combination as per the provisions under the Insolvency and Bankruptcy Code as provided under Sections 12 and Section 31 Clause 4 of the Insolvency Bankruptcy Code of 2016. So,